is Judge Angie Coble. So with that, I will call our first case, 128771, Dr. Troilo and Dr. Leiszler versus Gary Yager et al. Counsel, if you could announce your appearances, please.
Gary Ayers, on behalf of the Board of Directors of Delta Dental, the appointed Board of Directors of Delta Dental. With me is Charles McClellan, my partner at Folston Siefken, and for the corporation Delta Dental of Kansas is Ann Kindling, and on behalf of the elected directors is Tracy Hayes. And also with us in the courtroom is Jennifer Bauer, who is General Counsel for Delta Dental of Kansas.
Your Honor, is Forrest James Robinson for Dr. Mark Troilo and Dr. Christopher Leiszler. Also with me is my co-counsel, Wendell Snow, and the doctors are in the courtroom as well.
Very good. Counsel, you may proceed.
Your Honor, I will be arguing on behalf of the appointed directors and on behalf of the Delta Dental of Kansas Corporation. Ms. Hayes would like a couple of minutes to argue on behalf of the elected directors, and I would like to reserve 2 minutes of my time for rebuttal.
2 minutes is granted.
Thank you.
You may proceed.
Thank you, Your Honor. This appeal presents fundamental questions of nonprofit governance under the Nonprofit Dental Service Corporation Act and under the Kansas Corporation Code for non-stock companies, which is found in 1766-02B3. The Act's plain language vests in Delta Dental's Board of Directors the management of all of the affairs of the company. The Corporate Code's plain language vests in the board the authority to unilaterally amend the company's articles. Under the code, the board could, but did not, legally grant the members a right to approve articles amendments adopted by the board. To give members the right to approve articles amendments, the code has specific requirements that must be met, but they were not met in the present case. The trial court ignored the plain language of both the Act and the code and said the board did not have authority to amend the articles without member approval, notwithstanding the fact that in the 25 years since the 2000 restated articles, the board has never submitted an articles amendment to the members for approval.
Now, counsel, it's my understanding that there were a few amendments between 2000 and 2020. 2 of them involved changing the resident agent, is that correct? And 1 was simply changing the name of the company?
That's correct.
Those are in the stipulations, but the plaintiffs argue in their brief that there's no evidence the members were even aware of these changes, and the stipulations don't address that particular allegation. Can you speak to that? Did the members ever know about these changes, or were they given an opportunity to vote on them?
The articles amendment for the change of name, the members were aware of that. They did not vote on that.
They're aware of the resident agent change, or the corporation name change?
The name change.
Okay.
They were not aware of the resident agent change.
Not either of them?
Neither one of them.
Okay, thank you.
But the court went further, beyond ignoring the language of the code and the Act. The court went further. It correctly held that none of the appointed directors breached any fiduciary duty, a ruling which the plaintiffs did not appeal. The court granted equitable relief based on the same fiduciary principles that the board did not breach. Instead, the court invented a new cause of action called inequity that does not exist in Kansas or Delaware, and which upsets a century of settled corporate law jurisprudence, under which the courts do not substitute their judgment for the board's.
Counsel, I have a question about the interaction between the 2 counts. It's my understanding that count 1, the relief is basically declaring the 2020 amendments legally void, is that correct?
That's correct.
And then the second count, is that just an alternative add-on where they're also saying, oh, and they're void and we're requiring you to refile the old ones with the insurance commissioner?
Yes, it's an alternative claim, and what the court said was that, initially he said the appointed directors did not breach their fiduciary duty. Therefore, you can file a judgment that says judgment in favor of the appointed directors. Then, under pressure from the plaintiffs, they were worried that that would not be enough to invalidate the amendments in the event that Your Honors found that we were authorized to pass those amendments.
Well, the district court expressed that as well in his order. I mean, the district court said, hey, if I'm reversed on count one, we need count two. But on the flip side, just practically speaking, if we were to affirm count one, would we need to reach count two?
If you affirm count one, you do not need to reach count two, obviously, because his injunction and your order would say that we were not authorized and those amendments were void. Therefore, you don't need to reach count two. But you don't need to reach count two also because he found there was no breach of fiduciary duty.
But isn't count two, the reason behind the court's ruling in count two is basically that when we have no remedy at law in Kansas, the court has the ability to issue equitable relief. And the court was saying, look, there's no remedy at law for me once I've declared these articles, these amendments void to do anything. And so I'm forced to resort to equitable relief. I mean, that's how I interpret the order, but please let me know if I'm missing something.
Well, I think the thing that's missing is that when you declare the articles void under count one, then of course he has a remedy of striking them down as void and enjoining their use. But the problem with count two is that there is no such thing as inequity freestanding. To have a remedy under count two, he first has to find that someone, a person, a director, breached a fiduciary duty. There is no case in Kansas, there is no case in Delaware where a court substituted his judgment of fairness for that of the board just because he didn't think it was fair.
Talk to me about the Chanel doctrine. Isn't that what the court was employing, the Chanel doctrine from Delaware, basically saying we don't have a breach of fiduciary duty, but we have some conduct where someone was taking away the member's power to vote, some of their authority, and that's kind of, it seems to me, kind of that mid-range doctrine where it's not the business judgment, it's not enhanced business judgment, but it's kind of for these situations where we don't quite know what to do. Something seems odd, like there's a balance of power that's shifted, but we don't know what to do with it. So it seems like the Delaware courts have the Chanel doctrine, and that's what the district court was relying on in issuing its equitable relief, correct?
Well, there are two things about the Snell doctrine. First of all, it's been severely limited. There is no longer any compelling justification requirement in Delaware. That's been removed. There was never any compelling justification requirement in Kansas. And so the trial court's use of the compelling justification doctrine was error in and of itself, quoting Snell. The other problem with Snell is that there is, if you read it carefully, it is based upon a breach by the directors of a duty. There's a duty as to their relationship with the shareholders. And so there actually, if you take that whole Snell doctrine, blazes all the way through, there is no case that doesn't have some wrongdoing by the board, and not wrongdoing under count one, which because that's the ultra virus, that's the legal, the twice tested, that's the legal part, but wrongdoing under count two. And this court found that there was no wrongdoing under count two, but just said, you know what, I'm a little worried about my ruling on count one, so I think I'll just issue an injunction under count two without any breach of any fiduciary duty, without even getting close to a breach of fiduciary duty. So even under Snell, this court could not just issue an injunction without a breach of something. And there was no breach of anything. He just issued equitable relief. You have to have a claim, a breach. You have to have something against which.
I mean, we've got the 2000 amendments, which, correct me if I'm wrong, the board approved. changing to allow the members to have the ability to vote on amendments to the bylaws and the articles and those amendments, correct?
That's not correct.
I thought the board approved those originally in 2000. That's not correct?
What's correct, Your Honor, is that in 2000, there was a clause inserted that said that stockholders will have generic voting powers, which is sort of like a 176001. This is something you can include in the articles.
Okay, in Article 5, correct.
But it doesn't say that articles amendments, that they have the approval authority of articles amendments. It doesn't say that. And it doesn't say if they did have articles amendment approval, how would you decide how to vote? Would you have the vote of all the members, like 651 members out of 1,300? Would you have 6 members voting at a meeting called by the members? Is that how you would do it? Would it be a
But that specificity is not required.
Excuse me?
Where is that specificity required?
The specificity is required because the specific statute that tells you how to amend articles is 6602B. And it says, articles amendments shall be made and effected in the following manner. It's a mandatory requirement to amend articles. That language is not in our articles. So the statute says if you want to amend the articles and you're a non-stock corporation, the first thing is you have to do it in the following manner. They shall be made. And under a non-stock corporation, it says the board has the authority to amend unilaterally unless you have incorporated provision into your articles that tell you how many members have that right to vote on an articles amendment, or what class, or what percentage.
But that statute just says that the articles may contain a provision with those specifics. It's not required.
It is required because it says the amendments shall be made in the following manner. And in the following manner is that the board has a unilateral ability to amend the articles. It shall be made in the following manner.
So back to my original question then, what do we do about the fact that the board approved the changes to Article 5 to give the changes to the voting powers in 2000? What are we to do with that?
Well, first of
Fact.
all, the main thing is that you do with that is it does not tell you what those voting powers apply to. It's a generic 6001. These can be included in the articles, but it doesn't tell you that the members have the authority to approve an articles amendment. And so when you get to 6602B3, which is the specific statute which governs over the general statute, it tells you that if you want to amend the articles, you have to do it this way. That language, that voting powers language, doesn't do it that way. And it doesn't tell this court, it doesn't tell us, it didn't tell the trial court, even if you wanted to give the members some right to approve, it doesn't tell you how many members. And there is no default voting rule for members in the non-stock provision. If you look at 6602B1, stockholders have a default majority rule voting. If you go to 6602B3, the board has default majority voting to amend the articles. But when you get to the discretionary, you can include this provision. It doesn't have a default rule. It says you have to say, because we don't know, you can't certify to us, the Secretary of State, that these were properly passed unless you tell us how many are required to pass it, what percentage are required to pass it, or what class are required to pass it. Yeah, you may include those things in your articles, but to amend the articles, you have to tell us exactly how to do it. And that's the mandatory provision that our articles don't contain. Does that answer your question, Judge Klein?
Yes, thank you.
Thank you. In 2018, Delta reduced its fees on about 10 out of 700 codes, billing codes, to maintain affordable health care in Kansas, which was its purpose under the Act. In response, these plaintiffs created competing dental plans, and they repeatedly proposed bylaw changes that would have dismantled our corporation's insurance model. They would have increased the dentist-owned fees, They would have reduced or eliminated patient protections and cost controls that make care affordable,
Counsel?
and they would have
before
resulted in a breach of our subscriber agreements. Yes, Judge?
and I appreciate it, we're real familiar with the facts, but it's your argument, you can talk about what you want. Are you or is your co-counsel going to talk about the standing argument?
The elected directors is going to talk about standing
Okay,
argument.
thank you. I wanted to make sure I knew who to direct my questions to, and I didn't want to run out of time. before
If
we
you have
got
a
to that.
question, I can also respond if you would like me to on the standing issue.
It's whatever you're comfortable with. If your co-counsel is going to talk about standing, I'm happy to direct my questions to her. I just didn't want to run out of time before we got to that issue.
Sure, well, go ahead.
Okay. So on the standing issue, I guess I'm concerned about why isn't paragraph 80 of the petition and those allegations of the circumstances surrounding the letter in the adoption of the amendments, why wasn't that enough to plead demand futility? I would
Because-
like your position on that.
Because legal demand futility is not just whether or not the board would agree with you. The question is, are they materially benefited by something they did that would stop them from being able to exercise their business judgment? And so they didn't plead any personal material benefit. There is no evidence in the record that this $30,000 or whatever they get paid is material to any of the directors. And so the first,
Where is that in the statute? I mean, I'm looking at the derivative action statute. Where is a personal material benefit language in the statute?
it's in the business judgment rule, derivative versus direct claim of demand futility cases in
You're saying
Delaware.
that's a court interpretation of the statute?
That's exactly
But not
right.
the
That's
statutory language?
Exactly, both in Kansas and in Delaware. We take Delaware cases. You have to allege to rebut the business judgment rule, to allege demand futility, excuse me, I'm on the wrong subject, to allege demand futility, you have to allege and you have to prove that they have a personal material benefit that would prevent them from exercising their business judgment. So that's primary. And there was just no evidence at all that they were unable, and they admit that they didn't make demand. Their complaint was that, well, they passed the amendments, therefore they probably wouldn't sue themselves to reverse them or reverse them otherwise, but that's not the legal test, which we set out in the briefs. In the December meeting,
Mr. Ayers, you are getting into your rebuttal time, which is fine.
I'm sorry, what?
You're getting into your rebuttal time, which you're free to waive that if you would like, but just know that it's counting down.
Yeah, I just wanted to make sure that the court understands. I'll just use 30 more seconds. Two things. One, as Judge Klein has asked, the voting powers language does not meet the requirements of the statute. And so what are you to do with it? You are to require the voting powers language to meet the requirements of the statute. And if it doesn't meet the requirements of the statute, then it doesn't give the authority for the members to approve. And secondly, as to count 2, when you find no breach of fiduciary duty, you have found everything you need to find, and it doesn't need to be revisited. So I'll save my 50 seconds. I appreciate it.
Good morning, Your Honors.
Good morning.
Sorry, I
Nope,
didn't
you're
realize
fine.
you set it for 18 as opposed to the full 20. Just to clarify the record, because I do think there's a little bit of confusion, at least in the docketing orders. My clients did not join in the appeal related to count 1. We are only defending the appeal by plaintiffs' appealees regarding count 2. And although I was reserved more than enough time, the only argument or primary argument my clients have in that regard is they voted no. The entire arguments on behalf of the plaintiffs and the is that there was a breach of fiduciary duty in the passing of these amendments. all of my clients voted no. They were opposed to the amendments, and so I'm not sure what else they could have done to not breach their fiduciary
But aren't they
duty.
basically here because if you're going to order an injunction, I mean, if they're not party to the lawsuit, it's not going to be effective against them?
I agree, Your Honor, as it relates to count one at least. As to count two, though, if you read the petition as it's alleged, they are stating that the individual defendants violated the duty of care, violated the duty of loyalty, etc. So they have made individual allegations against my clients, and based on the pleadings, they have not proven those because, again, they voted no. Unless there's any other questions, I will concede my time to Mr. Ayers for the rest of his rebuttal.
Counsel.
Good morning. May it please the court. I want to be clear that there are two independent grounds for affirming the trial court. First, under Article 5, the members had stockholder voting powers, yet the 2020 or the 2020 amendments were sent through without a vote by the members. They are void, they are ultra vires. Second, if the amendments are found to be legal, they are also inequitable in substance because they removed the bylaws from the exclusive power of the members. They eliminated director fiduciary duty. They exculpated the directors from liability for breach of fiduciary duty. They granted virtual lifetime appointments to the directors, and they stifled member participation in the corporate democracy. They're also inequitable in procedure because of the secretive, heavy-handed manner in which the amendments were sent through. As to the first ground, let me be clear about one thing. I do not hear the defendants to be challenging the trial court's plain meaning interpretation of Article 5. It appears to me that their only challenge is that the amendment so interpreted would violate either the Act, the Nonprofit Dental Service Corporation Act, or the Corporation Code. As to the Act, and this is important because there was quite a bit of discussion about this earlier, as to the Act itself, the appointed directors cannot credibly argue that there's a direct conflict because the Act does not speak to how or who can amend the articles or the process for doing that. Instead, they concoct this argument that that it violates the director's power under 19A03 to manage the affairs of the company. But there is no language in the Act which gives the directors unfettered, unchecked, unlimited power to alter the core democracy, including the elimination of member voting rights.
Counsel, can you talk about the code restrictions? Because
I will.
That was the focus today.
I
And
will.
I would like a response to what I understand the argument to be that the Article 5 amendments didn't give the member, that back in 2000, didn't give the members the power to amend the articles and the bylaws, which is why we have these amendments that occurred between 2000 and 2020, where they didn't seek member approval of certain ministerial things, but that would give some credence to the interpretation that, hey, these voting powers didn't include that specific power. And that's why we acted the way we did in 2020. And then, oh, by the way, we have 17602B3 that talks about it's only the board that gets to approve these. And if you want to have the members approve amendments to the articles and the bylaws, you can do it, but here's the way you do it.
Well, the trial court was absolutely correct that 176602 is a default provision. There is no provision in the code that says that you have to specify how amendments are to be made. When the directors gave the members stockholder powers, one of those powers that stockholders are known to have is the power to amend the articles of incorporation. That's the power they had.
Then
You
why
don't
weren't
need
they
more
given the
specificity.
opportunity to do that over the years? Over the 20 years when you have these amendments, why weren't they given to the members?
Well, there was no amendment that was as cataclysmic as what we have here.
But does it matter? I mean,
Yeah, sure
does
it
the
matters.
quality of the amendment matter if this is the procedure? I mean, the procedure doesn't say, well, if you have a substantive amendment, then you have to go to the members. But if it's just involving this, then you don't have to go to the members. I mean, wouldn't the procedure be the same regardless of the type of amendment?
Well, in 2000, when these amendments came through that gave them voting powers and also gave them complete control of the bylaws, they voted on that. The later amendments, there is nothing in the record showing that the members were even aware of those changes. You cannot say that the members somehow waived their rights to vote on substantive amendments to the articles based on their lack of knowledge or lack of participation.
So the members didn't notice when the name of the company changed?
There is nothing in the record showing that the members had that knowledge. In my view, these are ministerial changes that ordinarily would not require member participation or member vote. I mean, you can
But
you can
again,
look at that.
where am I to find that distinction? In the code, in the corporate documents that distinguishes the type of amendment and who gets to approve the different types of amendments?
I don't think you're going to find anything that distinguishes that, but Your Honor, a waiver is an intentional relinquishment of a known right. There is no showing here that the members waived their right to vote on amendments to the articles.
Is waiver a doctrine that you relied on below? Was that
Sure.
pled in the petition? Maybe I missed it.
No, we absolutely argued that they did nothing to waive their rights. But Your Honor, continuing on, the importance of 6602 as a default provision cannot be understated, because what 6602 does is to set out conditions for the amendment process for both stock and non-stock corporations. Well, a fundamental canon of statutory interpretation requires that the statutes be read harmoniously so that they create compatibility, not conflict. The basic provision of the code that establishes that the code is essentially a gap-filling procedure is 17602. And 17602 actually explicitly states that for a non-stock corporation, the corporation can give the members, and the quote is, full, limited, or no voting rights or powers. So KSA 17602, if it's interpreted harmoniously with the purpose of the act and with 6002, since the Article 5 gave the members stockholder voting powers, then the controlling provision should be B1 of 6602, which is the provision for stockholders. It's
What's
not.
your response to the argument that Article 5 wasn't specific enough because it didn't include language like in 6602B3 that talked about, you know, the percentage, like we've got logistical issues with members voting on things in a non-stock corporation. It's a little bit easier when you've got a board, but when you've got like hundreds of members, you know, that we've got a provision here in 6602 that's like, okay, here's a logistical way you can solve this problem. But their position is Article 5 doesn't contain that specific language that's suggested in 6602.
Well, number one, there's nothing that requires such specificity. I mean, what's good for the goose is good for the gander. For a stock corporation, it's well known that the stockholders have that power. You don't see in the bylaws a specific, or the articles, a specific provision that gives them the power to vote on amendments to the articles. It's simply accepted. So by conferring on the members the same powers that stockholders have, that dovetails into B1, not B3, because that B1 is how stockholders would amend the articles. That's the only interpretation that makes the statutes compatible. It serves the basic harmonious interpretation canon. And that, by making 6602 a default provision, as the district court did, that makes all of these statutes harmonious. Thus, Article 5 did not violate either the Act or the Code. Moving on to the second ground, which is count 2.
And before we get into that real quick logistically, if we were to affirm count 1, do we need to reach count 2?
We do.
Why is that?
And the reason for that is that these are independent alternative grounds for affirming the trial court. So if you were to decide that the amendments are ultra vires and void under count 1, I think the Kansas Supreme Court would expect you to decide whether they are also inequitable. Because if this case goes up, both points are in play. And I consider the inequitable provision to be the backstop to the district court's ruling. But if it turns out that that you affirm the district court on count 1, I think it's important to go ahead and address count 2, because I think if this case would go up to the Supreme Court, the court would expect that.
So it's not legally required. You just want a belt and suspenders to give you that protection when you go up there.
Yeah, it's belt and suspenders, but I also don't want to get into the situation of having the Kansas Supreme Court kick this back down to your court to make a decision on equity.
On an alternative count.
Yes, on the alternative count. The what's really important about this alternative count is the district court was sitting in equity. And sitting in equity, it has tremendous discretion. You only reverse the district court if there is an error of law or an error of fact, and we don't hear the appointed directors saying that there is an error of fact. They only point to errors of law. And they try to confuse count 2 with the common law tort for breach of fiduciary duty. That is just incorrect. As we detailed in the verified petition, and we don't have a pretrial order, so the verified petition controls, but as we detailed there, we clearly identified count 2 as the second prong of Delaware's twice tested formula. There was never a challenge to the formula itself. It was always accepted that that would be applied in this case. We described a breach of loyalty by the board when they approved, as a board, the amendments, when the amendments were inequitable, and gave the directors huge benefits that they would not otherwise receive. We also asserted that the plaintiffs had no adequate legal remedies, and we requested coercive relief. That's a classic equitable claim. We have not asserted breaches by the directors on a director-by-director basis. We didn't assert that. We didn't try to prove that. We have not sought individual liability of directors. We have not sought damages from the directors.
Council, if the members had approved the 2020 amendments, would you have grounds to bring count two?
No.
It's really just the quality of the amendments and not the, count one's about the procedure and count two is about the content.
Well, let me put it this way. If the members approved the 2020 amendments, we wouldn't be here on either count one or count two.
I understand count one, but count two, you seem to be talking a lot about the content of the amendments.
Right.
And so I was wondering if that's really the focus of count two, if it's the content or if it was the procedure used to enact them.
It's both the content and the procedure, you know, so, I mean, you have both elements here. You have a secretive procedure where two of the directors arranged this meeting and kept the other 8 directors in the dark. And those directors were then blindsided with these amendments at the meeting.
But that really wasn't what infused the district court's decision. I mean, that happens a lot. You're in a board meeting and you find stuff out that morning and they could ask for time. They could try to ask for time to look at things and consider it. I mean, they had a vote. They get outvoted. Wasn't the court really more concerned with the shift in the balance of power that the amendments affected?
No, I don't think so. I mean, the district court made findings that they were substantively inequitable and that they were procedurally inequitable. The secretive procedure is a significant part of the district court's underlying decision. But what we have here is the defendants simply do not understand the distinction that Delaware law makes between challenging a board decision as inequitable and a common law tort for breach of fiduciary duty that would hold the individual directors personally liable for that decision. It is a clear differentiation in Delaware law. The second prong uses enhanced scrutiny. The appointed directors say that the court used the wrong test. They're trying to work their way into a legal argument for challenging the trial court's discretion. But the trial court did exactly what the enhanced scrutiny requires. They looked at the threat. They looked at the reasonableness. They looked at the proportionality of the board's response. The court then made extensive findings and conclusions that they were both substantively and procedurally inequitable. These findings and conclusions should all be reviewed for an abuse of discretion. First, the appointed directors are opposing that by saying, no, the district court actually applied the entire fairness review, not enhanced review. They are seizing on 2 words in a very lengthy oral ruling from the bench. The court never said it was applying entire fairness. And if you look at the entirety of the court's comments, it was addressing each of the enhanced scrutiny points: reasonableness, the threat, the reasonableness of the board's response. Second, they argued the business judgment rule should apply. The business judgment rule is a standard of non-review, but Delaware and Kansas cases both have held that where the board's decision allocates or implicates the allocation of power between the shareholders and the directors, the business judgment rule does not apply. Here, the board's action drastically altered the core governance of the corporation by eliminating the members' effective participation in the democracy. The business judgment rule simply does not apply. The court did not err in applying enhanced scrutiny. Third, they challenged the court's conclusions as to the threat and as to the reasonableness of the response. But, Your Honors, this is an abuse of discretion situation. they have not shown an abuse of discretion by the district court. In sum, there were no errors of law that would justify the court in refusing to defer to the trial court on these findings, and we therefore ask you to affirm on both counts 1 and 2. There were questions about standing. I will hit on that just very briefly. The appointed directors are trying to make a standing argument as a constitutional question, but the constitutional test for standing in Kansas asks only 2 questions. Was there a conceivable injury that was caused by the conduct of the defendants? Neither demand futility nor adequacy of representation touches on constitutional standing. These are procedural issues. And as a procedural issue, they are reviewed for an abuse of discretion. I think they're trying to get to constitutional standing because they potentially get de novo review. But these are discretionary acts, and there is no showing that the court abused its discretion. Your Honors, I'm happy to answer more questions, but I'm out of time. Thank you.
Thank you. Mr. Ayers, you have 2 minutes rebuttal.
Thank you, Your Honor. Counsel mentioned, as I mentioned, that there's a generic statute at the very beginning of what can and cannot be included in the articles. And one of those is that you can include voting rights or voting powers. That's 6002. Counsel mentioned that, I mentioned that. But what counsel leaves out, what the court leaves out, is that to do an articles amendments shall be made and effected as follows. That's not the default rule. That's not a discretionary rule. That's how it is to be done. That's how the legislature said. If you want to amend the articles, they shall be made and effected as follows. And it just didn't happen in this case. To answer your question, Judge Klein, in 6602, you were asking for the place where you can change a name. You can do name change without approval, but you cannot do resident agent change without approval, and that's in 6602. You may have already known that, but I'm just asking to see if we knew it. We were not arguing waiver. What we were arguing, what everyone has been arguing in that point, is that it was sort of a course of dealing, the board's own interpretation of whether or not those voting powers required member approval. It's not, no one was arguing waiver. On the Schnell case, if you go back and read Schnell, the court was talking about self-dealing by the board, and that's why you had Schnell. Personal futility, I mentioned the personal material benefit. I forgot to mention that you also have to have personal liability before demand is futile. On the voting powers under the Act, if it's as plenary and as full-throated as plaintiffs say, then it violates the Act, because if you give all voting powers to the members, then they would have the right to elect the appointed directors. Of course, they don't have that right. Therefore, it would be illegal and could not be included in the articles. Twice tested, yeah, we went ahead and talked about that. That's never been adopted in Kansas. You would be the first to adopt that here. The court said there was no breach of loyalty, no breach of care. He did not rebut the business judgment rule because he did not have any issues of control. He did apply the entire fairness test under Becker. He did require compelling justification, which is not the test in Delaware or in Kansas. So with that, Your Honor, we ask that you would reverse on count 1 and also reverse on count 2. Appreciate that.
Any further questions? Thank you, counsel. The court will take this matter under advisement and issue an opinion as quickly as possible. Thank you, counsel, for both your arguments.